Hi there, Barb Teachblade Reynolds here, Tehachapi Court Services, as well as blog author of Paralegal Brain the Blog, and the 330 video series for paralegals and young lawyers. I'm starting a new series called SOP, Standard Operating Procedure. There are some things that you do in a law office, and you do them without waiver. They become your standard operating procedure. You may not know why at that point, but if you deploy those types of unswerving processes, if something does occur, you'll certainly be glad that you had that procedure in place. For example, when you are preparing a divorce action here in California, there's a summons that you serve with the petition for dissolution of marriage as well. That summons, on the back of that summons, page 2, there is some automatic restraining orders that go into effect the moment the respondent is served, and they go into effect the moment that the petitioner files his or her petition and summons with the court regarding the divorce action. Those automatic restraining orders essentially preclude anyone from transferring large amounts of money. You can make certain transfers or withdrawals within the ordinary course of business or for some necessities of life, but no large transfers that would violate or interfere with the other party's community property interests. There also may not be a transfer of or deletion of someone from an insurance policy once both parties are served and under the jurisdiction of the court. And say, for instance, later on it's found out that the respondent has made a significant transfer to an unknown bank account. Well, there could be some repercussions from that, asking that the respondent be disgorged and return those monies to the community joint account. Say, for instance, the respondent says, well, I never got notice of the automatic restraining orders, that I could not do that. Well, one of the ways in which you could establish that he had knowledge, or there's a huge legal presumption that he did have knowledge, is to have the summons two-sided. In other words, don't have two separate pieces of paper that constitutes the summons, but have the summons two-sided so that you can flip it over, and the summons, the original summons that's within the original court file, will contain that two-sided summons, so that the judge can see that if the original summons and if the petitioner summons is two-sided, there's probably a huge probability that the respondent received a two-sided summons as well, and therefore had personal knowledge of the automatic restraining orders that forbade any type of transfer, large transfer, once the action was in full before the court. Hope that helps. Always remember, establish some type of procedure that's a standard operating procedure that you will not swerve away from, because in certain instances it could pay off to be able to establish that that was the SOP, the standard operating procedure in the office. You guys take care. Have a great weekend. And always remember, make today your masterpiece. Take care. Bye-bye.